Now we'll have the Lewis County matter. Begin with appearances on the record, please.
Glenn Carter on behalf of this.
Good morning.
Your Honor, Joseph Thomas on behalf of plaintiff Brian Cortland.
Good morning. So, this comes before the court on summary judgment. Let me get situated here for a moment. The court has reviewed all of the materials and briefings submitted in connection with these motions. I will indicate at the outset that I have honed in on discrete issues, and I have, in effect, one question for each side. Given that it's summary judgment, I will allow additional time for argument if you are so inclined. I will indicate, however, as both of you are well aware, that I don't necessarily need a lot on summary judgment arguments given that there's been briefing, and so take that into consideration when you speak. And so I will hear from Mr. Thomas first, and my one question to him is, given that this is not a case where there is an allegation that public records have not been turned over, rather, this is more a concern about the entity from which those records were received and the process through which those records were given, what authority is there that the Public Records Act in Washington still provides for a cause of action in those circumstances?
Thank you, Your Honor. I'll go ahead and try to address your question as best as I can. And I feel like this has been addressed fairly well in the brief, so I'll just kind of highlight the parts in the brief where we feel like there's authority.
And I'll make a more discreet question. Can you cite a case where documents were given, but an appellate court said there was still a cause of action?
I can't, Your Honor, but I also cannot cite a case that I know of where documents were given outside of the Public Records Act context, but were claimed to be subject to the Public Records Act. But I think when we go to the plain language of the statute, it becomes abundantly clear that non-agencies cannot provide records under the Public Records Act in order to avoid liability. And this was discussed in Mr. Cortland's response to Lewis County's cross motion for summary judgment. I'm talking particularly on page 6. In the plain language of the statute, we have to look at the plain language when interpreting and discerning the legislature's intent, like this court stated before in the legislature's case. The plain language only permits agencies to produce records. It uses the word shall several times, and shall is construed by the Washington State Supreme Court, to confer a mandatory duty upon agencies. And if they wanted to confer a mandatory duty upon agencies, it would render that meaning optional if other agencies could produce the records and the agency didn't have to, which is this case. The record is clear that Lewis County did not respond to Mr. Cortland's request. Lewis County did not provide any records, and if the Superior Court or any other non-agency could come in and provide these records, that would change that word, the meaning from the word shall, to an optional meaning, meaning possibly, probably, or some other word. So we're changing the word shall from something else, and like this court said, the court doesn't have the authority to do that. The court needs to follow the legislature's words, the plain meaning of the statute, and the legislature's intent. And the legislature's intent through several parts of the statute and through Washington State Supreme Court case law is for the agencies in order to respond. First of all, this can be seen in RCW 4256070. This can be seen in RCW 4256080 and 42560 520, Section 1. Let me start with RCW 4256, 520, Section 1. Even Mr. Carter agreed, or even Lewis County agrees in their cross motion that RCW 4256, 520, Section 1 says that agencies shall respond to public records requests. That creates a mandatory duty that agencies shall respond and have to respond and have a mandatory duty to respond. If non-agencies like the Superior Court can respond, then it circumvents the entire meaning of the Public Records Act. RCW 4256-080 uses the word shall to state that agencies shall, upon request of identifiable records, make them promptly available. Lewis County, the county, the entity that sued, the agency that's subject to the Public Records Act, did not make the records available. This lawsuit has been the violation occurred in April, in August and September of 2016, and these records still haven't been made available by Lewis County. There still hasn't been a response by Lewis County. The legislature intended for the agency to respond, the agency to produce records, and gave them a mandatory duty in order to do so, and it would circumvent the entire meaning of the Public Records Act in order for them to do so, in order for it to make it optional for non-agencies in order to respond. Third of all, agencies also have a mandatory duty to search for records and to make a sincere search for records, both under Washington state case law and under federal case law, like I provided in the briefing. If agencies don't have to search, how do non-agencies know where the records are located? How do non-agencies even know if all the records are being produced? The reason why agencies have to search is because they know the layout of the land. They know what records are in their agencies, they know who to talk to, they know where to search. There has been no evidence, there is no proof in the record that Lewis County even produced or even conducted a search for these records. There's no affidavits, there's no even argument that Lewis County even made a search for these records. So the reason why the agencies have to search for these records is because non-agencies won't know where to look, who to ask, or what to find. And so it's just logical that agencies have to perform their own search, and case law is very clear. Neighborhood Alliance versus the City of Spokane was cited in the brief, and also in federal case law, DeBrew versus Atwood, 792, Federal 3rd, 118, from the District of Columbia, Circuit Court, 2015. Does that answer your question, Your Honor?
It does.
So Lewis County failed to perform search, a non-agency prevailed to search. Agencies have mandatory duties under the Public Records Act, and by allowing non-agencies in order to perform those duties, it circumvents the intent of the Public Records Act, and I don't want to belabor this point anymore. It's in the brief.
Thank you very much.
Thank you.
So, Mr. Carter, I don't need to hear any substantive response to the core issues, let's say, on this case. My question to you is something that was raised in Lewis County's brief towards the end, which was somewhat confusing to the court. That is the suggestion that my order and Judge Dixon's order conflict with one another, and that Lewis County is currently operating under the assumption that it has no obligation under the law to operate or have a law library board, and that any records associated with the law library board, type of work that would be done by the board if it existed, are subject only to GR 31 and not to the Public Records Act. Am I reading that correctly, that that is Lewis County's position in this case?
Your Honor, Glenn Carter on behalf of Lewis County. Your Honor, my difficulty with your decision in the Cortland one, it's what I call it, that's the first case that we came before you on, has not been so much, while I disagree with your decision, obviously, that those are PRA records, I disagree with that. But what you went on to say in that ruling was to not only say that the court was the Lewis County Law Library Board during that period, but you went on to say that the Law Library Board is a PRA agency. I understand that part. And I think that you can say that a judicial agency is a PRA agency under your ruling. And again, I'm not agreeing with your ruling, but As I understood your ruling, let me just, and I don't mean to take all of your time, but I do want to explain to you where I'm coming from on this issue, because obviously I wasn't clear. But you have a membership and a function test. And the membership and function test, if you take the hypothetical diversity task force that I used in the briefing, where you have 2 judges that sit on that and 3 members of the bar that sit on that task force, under the test which you stated, that would not be that would not be a judicial agency.
So I guess is this a yes? You are interpreting Judge Dixon's order and ruling as conflicting with mine?
I am only as to this point. To say that that is a PRA agency is not the same as
Was
saying
the
that it's a
PRA
county
at
agency.
issue in Judge Dixon's case?
No.
So how does it conflict with the ruling in my case?
Because you said it was a county agency and Judge Dixon said it was not.
Judge Dixon said it was a county agency?
He said it was not.
He said it was not a county agency? Where does it say that in his ruling? Which I have before me, and I'll save you the time. It doesn't say that in his ruling.
No,
It
Judge.
says the Board of County Commissioners could not compel a Superior Court judge to serve on such a board, but it doesn't say that it's not a county agency. In fact, it says on the first page that Lewis County must have a board of law library trustees.
Your Honor, I sense what you say, but I think you don't quote.
Sorry, let me short circuit this. Is Lewis County now going to be operating under the impression that it doesn't need to have a law library board?
Your Honor, please, may I answer the question?
I'm in charge of this hearing, and I want you to answer that question. Is Lewis County now operating as if it doesn't need to have a law library board?
We have a decision that we interpret from Judge Dixon that says that we as a county, the Board of County Commissioners, cannot appoint a law library board. That's what Judge Dixon said in paragraph 7.
Okay, so you have 2 choices. I have one order that issues Rule 11 sanctions for an argument that is not well-founded under law or an argument for change of law. And I have another where you withdraw that argument and indicate that that is not the law. I'll indicate I'm well familiar with Judge Dixon's case. Judges talk to one another. I understand the issue in Judge Dixon's case. And I'm going to let you choose which of these orders I sign today.
So, Your Honor, let me be clear. One is sanctions against me for saying that it's not a county agency.
For saying that Judge Dixon's ruling conflicts with mine, also for saying, and I'll quote from the order that I may sign, that they are, law library boards and superior courts are not county agents or agencies for purposes of Washington law, which his order does not say, that the county is not responsible to create or maintain the law library board, which it does not say. And in fact, as to that later point, his order expressly says the opposite. Lewis County must have a law library board.
Your Honor, I sense your anger, but please let me ask one question on that. Let's say that you're correct and that Lewis County as an entity has to have a law library board. How does it appoint it? The Board of County Commissioners can't appoint it.
And that's not my point here. My point is that Judge Dixon never said that Lewis County doesn't need a law library board. In fact, he explicitly said that it must. Yet you are arguing that he said something that he didn't say.
But Your Honor, I am talking about Lewis County as a geographic entity. I'm not trying to be obstructionist, Your Honor. I want to do what you want me to do, okay? I want to obey the law here. But he did say the Board of County Commissioners cannot appoint it. Why can't the judges appoint such a law library board and Lewis County would then have a law library board? Why can't it be the judges that do that?
The law says they can't. The law says that it must have the judges, the Bar Association, and a Board of County Commissioners member. The court doesn't get to rewrite the law because it thinks it's expedient.
No, Judge, again, I want to just understand. The member of the Board of County Commissioners is already appointed to that board. There's nothing that needs to be done. That's done by statute under that act. But Your Honor, with respect to appointing the other 3, if the Board of County Commissioners can't do it, Judge Dixon did say that, didn't he? In paragraph 2? Just so I'm clear. Paragraph 2 of his order says, RCW 2724-020 does not require nor empower the Lewis County Board of County Commissioners to select or appoint a Superior Court judge or members of the County Bar Association as trustees of the Lewis County Law Library Board. So the BOCC can't do it. Who does it? Who does it? If the board can't do it, that's the executive agency of the county. Who does it? I don't know who does it. Do I go to the judges?
I don't know, we have a whole hell of a lot of other counties in Washington State who have figured this out.
So you're asking me to say that the Board of County Commissioners can't appoint it, and that if I don't withdraw my position on that, that I'm subject to sanctions, where even Judge Dixon, as I read his order, says the BOCC can't do it. There's no one else that it can appoint in the county. No one else. There's no other body in the county that can appoint people to a board. I don't know how to do it, Judge. If the other counties had done it, they didn't do it through the BOCC appointing it. If they did, they didn't do it. That's not what Judge Dixon said could be done. I'm not trying to mischaracterize what he says. I don't know how to do it. Does the prosecutor appoint him? I don't know. I assumed what that meant was that the judicial body could appoint a law library board, and then you would have a law library board in the county. Because that's what I thought Judge Dixon said. And the jump that I saw, just for the record, is that, yes, you found that it was a PRA agency, but that doesn't necessarily mean it's a county agency. But if you were going to say that I'm going to be subject in the county, obviously, subject to sanctions for making that argument, I withdraw the argument.
Anything else?
Yes, Your Honor. We also have an issue of CR11 sanctions for Lewis County making repeated false statements of material fact and law by saying that the judiciary is subject to the Public Records Act. That has been dealt with in Nass versus Michaels. That's been dealt with in the City of Federal Way versus Koenig. That's been dealt by this court expressly in its August 2nd, 2017 amended order on the merits. This is a continuing pattern and practice from Lewis County of misstating law and fact.
The court is prepared to rule at this time. I am granting Lewis County's motion for summary judgment in this case. There's no authority under the Public Records Act or any case law interpreting that provides a private cause of action where documents have turned over. In effect, the complaint here is that the return address of the documents here came from the wrong entity. As Mr. Carter cited appropriately in the other case, I'm going to call it Cortland 1, we cannot do with the Public Records Act what we cannot penalize violations of other laws in the Public Records Act. That's in effect what's seeking to be done here. We are trying to say they don't have a law library board, so we're going to penalize and punish them under the Public Records Act for failing to have that board. That is not something that the court is able to do under the Public Records Act. The appropriate remedy for such an issue is a writ of mandamus. The plaintiff sought a writ of mandamus in this jurisdiction that was appropriately denied as futile because it was filed in the wrong court. The Superior Court of Lewis County is not an inferior tribunal to a fellow sister court of the Superior Court. I'm not going to make any ruling as if that had been ruled and filed in a different court because that is not where I am. But in essence, it was filed in the wrong court. And so, but the writ of mandamus and associated relief is what you are to do to address these issues and not to repeatedly get penalties and attorney's fees under the Public Records Act to, in effect, punish a county into the proper action to comply with the Public Records Act. And so I am dismissing this case with prejudice. I'm also denying in whole the motion for CR 11 sanctions. And I'll note that I'm relying upon the withdrawal of the representations in so doing. Do the parties require any clarification from the court regarding that ruling?
Your Honor, if I might, just for my own application, and again, I very much apologize to everybody. Your Honor, is it your reading of Judge Dixon then that it's a question just of venue, of the wrong court? That's how you read his order?
That is how I read his order.
I never thought of that. Thank you.
So I have this order. Mr. Thomas, do you have anything to add?
Yes, Your Honor, I have a clarifying question. Mr. Cortland argued that there is a question of whether records are still being withheld. Mr. Cortland never said that all the records have been produced. And in fact, today, I argued on behalf of Mr. Cortland that there was an inadequate search and we have no way to know if all the records were being produced because the agency didn't produce a search and there's no proof in the record whatsoever that a search was made. Is your order encompassing that too, that a complete search was made and that all the records were produced?
And I'll indicate my ruling covers every claim that is alleged in the complaint, and as that was not identified in the complaint, I am dismissing the complaint with prejudice. I am not speaking to any other claims. So I will leave it at that.
Your Honor, I'm sorry. Obviously, there was a search or we wouldn't have produced records.
Understood. So also, I have completed my order from Cortland 1, and I have filed that with the clerk, and I have 2 copies for courtesy copies for counsel, which you may now get from the clerk, and I am filing the order from Cortland 2, let's say, right now.
Thank you, Your Honor.
Thank you. Have a good weekend.